Good morning, good afternoon.
Good morning, afternoon.
If you put in under oath, please.
If you could both raise your right hand. Do you solemnly swear, solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
I do.
Yes.
Okay. Ma'am, starting with you, if you could please state your name and address for the record.
So have him also complete an updated parent. So we can get that on the file. So this was your post-judgment motion for modification, and you two came to an agreement?
For a partial, yes. Okay.
Motion to transfer. What is that?
So I filed a motion to try to transfer the cases to Milford because of where I reside. And so there's a hearing there's two separate hearings for two separate dockets we're involved in. And one's May 6th, the other is June 14th. So we were asking to wait to see if that gets granted before we do anything else, so we don't have to keep coming back to different courts.
So were you objecting to that transfer?
Yeah, I don't want to go. I don't want to have to go all the way out to Milford. I live in New Britain. I'd rather just stay here. The courts are familiar with our case here. It's just I don't feel the need to transfer it.
Okay. And you live in New Britain, and you live in?
I live in Orange, and the child has lived in Orange since birth, so really it's under Milford's jurisdiction, and he checked, and Milford's only an extra 10 minutes drive from him from New Britain. He's driving substantial amount of distance anyway. For me, the cost of with the downtown parking and everything, it's just really expensive every time to come here. So that's why we're hoping we can have a hearing on that.
Mm-hmm. Okay. All right, so I'm going to adopt your agreement as it relates to the outstanding issue, which was the post-judgment motion for modification. And the modification was primarily on the issue of a visitation schedule?
Yes.
Okay. So the you can both be seated, please. So this agreement is going to resolve all your other motions except the motion for transfer. Is that correct?
Not the motion for contempt.
How long ago was that filed?
Originally, it was filed November 21st, 2021, I think, and another one was filed, I believe, in January.
Of this year?
I believe so.
I also have pending motions also.
What's your motion?
I believe custody, go over our whole agreement, but I think we're pretty squared with the agreement end as far as visitation, and then also contempt.
All right, so I see your contempt motion. You have child support orders in the magistrate court.
Yes, which they stated that maybe everything would have to be handled now under magistrate. However, like Matthew has not paid any child support since November, so that was the original contempt, was about money, about child support. Mm-hmm. And now that support enforcement has magistrate, it seems that they want everything to be under that court.
For the purposes of child support?
Correct.
Okay, so their jurisdiction is around the child support matter. Our jurisdiction is, okay, you understand that?
Right.
Okay. So that means then that your contempt citation is to be handled because that's about the money? So let me just look at it. Countless times he has had strangers, a 2-year-old. So your contempt motion that's dated February 14th of 2022 seems to be about this issue that you resolved today.
Well, one of the things I mentioned in there was about the right of first refusal. So I just want to make sure I always, if it's not the maternal or paternal grandparents watching the child, that I get at least asked first. Even if I say no, I'd like to at least have that right. And if Matthew could please, do that. That was really what the contempt mostly was, with that and the money part. And also we had an issue about the drop-off part, which seems like we have a good plan for now. So that should hopefully resolve a lot of those issues.
All right, so let me read your motion, okay? The right of first refusal, strangers watching your child, didn't show up for a designated visitation and was refusing to return her to you, and he states that he will follow any part of our agreement. He has not paid child support or child care costs in 5 months. So this motion still has components of it that are still outstanding that you need a hearing on.
I mean, I feel like I'm okay with this agreement as long as, that he can follow through with giving me the right of first refusal moving forward.
Is that in the agreement?
It's already in.
Documents open. So does your agreement address that issue?
Well, nothing was changed with that. It's in our original agreement from June. So it does say, like, it's number 1 that we have to give each other the right of first refusal. So I just want to
that it's complied with.
Make sure that we're doing that, and doing this will resolve the issue with where we had with the drop-off point, which was causing problems with us. And now that we came up with a solution, I feel like that eliminates all of that not showing up.
All right. So I'm going to have 137 go off. Okay.
I'm sorry. What?
I'm going to have that motion go off.
Okay.
What that means is you're telling me that theoretically all that you've agreed to today combined with the original agreement resolves that motion.
Yes.
Because the court needs to condense what it's trying to pay attention to, and so that's one way of condensing it is by having that motion go up.
Yes.
Right. So you had a contempt citation that was scheduled 3-9. So listen, I'm reading this stuff as being almost like you guys are constantly using the court to resolve what you have to learn to at some point resolve, and that's raising your child together in an amicable way. Because as I read this motion, mother has not followed the agreement in any way. What does that mean? Dad has taken full responsibility for raising the child. Matters for custody have been filed. What were you trying to tell me?
So for the past month and a half, especially, and even multiple other times in the past, she just would refuse to take our daughter back at her time. So our scheduled time was I take her Friday evenings to Monday mornings. She would take her Monday mornings to Friday evenings. And she just stopped taking her. She would get mad at the fact that I was behind on child support. Well, if you can't afford your child support, and I also have a bunch of emails and text messages and all that proof here if you do want to see it today, of her just constantly refusing to take her. And poor Angelina's, getting upset, crying all the time that she, because we were following a schedule where she'd go, Mom, and then she wasn't seeing her mom for almost 3 weeks at one point.
Mm-hmm. And so what was the court order in terms of your schedule? You said what?
It was I would take our daughter from Friday evening to Monday morning, and she would have her Monday morning to Friday evening.
And the child goes to school in Orange?
She's a minor. She's only 2.5, so she doesn't go to school yet.
Okay. All right. So are you complying with that?
So, Your Honor, everything that he's just said was not accurate. I never didn't show up to get the child. He was using the loophole of we had the meeting place, which was at somewhere that we agreed on in June, based on a job I used to have, which I quit that job in September. So since then, he had been bringing her to my mother's every week since September instead of that meeting place that was designated. And he was also paying, when he stopped paying child support, he was still paying his half of court-ordered child care so that I would be able to work, since I do have the child 75% of the time. And so, I said to him, like, when you drop her off at my mother's, please make sure you send me the money for the week, because it's always due on Monday for child care, whether we had her in a home daycare, and then we took her out of that because she couldn't get a flu vaccine in time, and it was mandated, and it was like such a short period of time that the pediatrician didn't have it. So after that, I started having my personal private babysitter watch her in our home, and Matthew was paying, and then he stopped paying. So the issue about the money is still ongoing, and it didn't get resolved on 3/9 because I was actually late to court, and so they called us and I wasn't there, and then he got up and said to them, oh, well, I'm filing for sole custody. So they said they wanted to wait and see what happens with custody. He has threatened me many times, saying he's going to lower my child support or file for sole custody so that he doesn't have to pay child support anymore, and uses that as a way to intimidate me. And I feel like we had a great discussion that ended up well with all of this. And I feel like by what we wrote here about the drop-off pickup eliminates the issue of...
You didn't answer, and I hear you on all of that, but my question to you was, you guys have a schedule, so are you complying with that schedule by having your child on the days that you agreed to?
Yes, and on the day that he's discussing where he claims I didn't get her, I told him to bring her to my mother's like he usually does, and he stated, if you don't come to the gas station at this time per the court order, that I'm not going to, that either you go there at that gas station, if you're not there within 10 minutes, I'm leaving, and I'm assuming that you abandoned her, and I'm going to go file for custody. So it's just seeming that he's using the court as a weapon.
Does this agreement modify the place of pickup?
Yes, it does.
Okay, all right. So therefore, based on that, I'm going to assume that 140 is also going to go up.
What's 140?
140 is your motion for contempt, which basically mother has not failed to follow the agreement, dad is taken full responsible for managing said child, matter for custody have been filed.
But that's still an issue. It's been an ongoing issue for over a year now.
So listen, you guys have an agreement. You guys have an order of the court. That's what you comply with.
She doesn't.
Reasonable people realize that circumstances change and make reasonable adjustments. This is going to be another 16 years that you guys need to work together to basically parent your child. Circumstances are going to change. If one is reasonable and the circumstances seem reasonable, a minor adaptation to the pickup place is not a big deal. It's not. And those are the things that somehow you guys have got to start working on. So I'm reading this that based on your new agreement that the pickup is at mom's house, your mother's house, that addresses this, and that you will comply with your dates for pickup, and he will comply with his dates for pickup, correct? Is that my understanding?
Yes, and we spoke to my mother as well as his mother. They both were in agreement of these terms as well.
Okay, so 140 is off.
But, Your Honor, may I speak?
Yes.
The issues weren't just the meeting location. It's come down to the money, because I have multiple text messages from all different days. I have one from March 7th.
So listen, young man,
Yes.
when the court enters an order for child support, that's what you pay.
Yep.
You don't get to change it.
No, I know that.
You don't get to change it until you have asked the court for a modification, and the court basically hears the facts under the basis for which it's modified. Your obligation for your child is your obligation.
I know, and this is what I'm getting at, is she's saying, I have in the email where she's saying to me is, do not bring anything to my mom unless you Venmo me the child care money. She's refusing based on the fact that I'm behind on child support. Same thing on January 2nd. Since you're refusing to let me talk to her, pay child support, you can keep her all week since now I can't go grocery shopping and you're effed up and blah, blah, blah. Like, I have tons of dates like this.
So it's the same for you. The understanding is when there's a court order until it's been modified, I hear you. You have the ability to file a motion for contempt on the issue of child support and to have the court consider what that payment and arrearage needs to be. But you guys just don't get to decide that you change the circumstances unless you come to an agreement. Okay? So, because that's what keeps us sane and consistent, is that when there's an agreement, you follow the court orders until the agreement has been changed.
May I speak?
Yes.
So she's been constantly not following it with zero repercussions. That's why I wanted to bring it to the court today. So now when we take this new agreement, what happens in the next month or two when she's still doing the same things over and over again, not showing up for it,
Let's go through your
refusing?
motion, so I just get to the place where, as I said, we're going to pay attention to those that are still of issue versus those that have been resolved through your agreement.
When you say resolved, you mean that she's saying that she's now going to follow the agreement, that this new agreement, as opposed to our last agreement that she said she was going to follow and didn't?
Right, because sometimes when there's a contempt issue, if you guys come to court and you reset, right, and you agree that moving forward this is what you're going to do, that resets the agreement because you two have now come to a new agreement.
So even though I've been doing the majority of all the parenting and taking Angelina for
But
like
there's
25 days out of the month,
How do you
I
want me
still
to
must.
resolve that? Because it's not going to be a reduction in your child support.
I don't want a reduction. I want to take Angelina full time. I would like that primary residency of her.
Sir, that's a very high standard.
That's okay.
So you'd have to have a hearing on sole custody.
That's what I
Let
want.
me get to that motion. And let me tell you the standard for that.
Okay.
You have to show a substantial set of circumstances that would indicate to the court that this child's well-being is of concern that would warrant you getting sole custody.
Absolutely.
Our goal as a court is to make sure that two parents are basically considered fit parents unless something demonstrates that she's an unfit parent.
Okay.
It's the only basis under which the court would consider sole custody.
Okay.
This is not based out of disagreements and anger. It's based out of what's in the best interest of the child. The court's presumption is that a child should benefit from having her father and her mother involved in her life unless one of you has demonstrated that given your circumstances, it's not in the best interest of the child and could be unfit. So it's a high threshold. It's not based on your everyday disagreements, okay?
Yep.
All right. So let me find your motion that you filed for sole custody.
Your Honor, may I say something, please?
Sure.
Also, I just wanted to mention that Mr. Lodice has consistently been saying that he is financially indigent and unable to pay his child support because he claims that he has no income. So I just would like to know how somebody who has no income and no assets or is financially indigent would be able to take sole custody of a child. Is that something that the court takes into account?
You know, I wouldn't worry your head about that right now.
Okay.
That's a pretty full-blown hearing.
Okay.
That's not something the court takes lightly to make a decision on.
Okay.
This is not going to change overnight, and so people have a right to file whatever motions they want to. The court also will hear it and make the decision.
Okay, because I also did file for sole custody as well, and one of my motions to modify.
That's what I'm telling you guys. Here's what's reading to me, right? So the old lady sitting up here. You guys are getting in a tit-for-tat, and raising a child is not a tit-for-tat. It's a collaborative relationship that is designed to enhance your daughter's life and teach her how to be an adult in adult relationships. This is not about tit-for-tat. And so the decision about sole custody is something the court takes very seriously. Okay? All right. So, so it's not like you file a motion, you file a motion, you get to file a counter motion. That's not what we're doing here. It needs to be based on something that's legitimate. Where's your sole custody motion, both of you?
I filed a motion for modification. It was the most recent motion for modification that I filed with the ex parte, and that was, I believe, on 3/17, which I said changing to sole custody. But again, after meeting today with Family Relations, I thought Matthew and I made some progress, and I feel
And
that
here we are, right?
I feel like if according to this, we're okay with continuing the way it is, but if he wants to keep fighting in court and going tit for tat, I just feel like it's not benefiting our child at all. And really, he has his other two children on the weekends. I have my daughter who I have sole custody of during the week. And so it matches up perfectly where our child gets to be with her sister during the week, Monday through Friday, and gets to be with her two brothers on the weekend. Matthew's able to work. I'm able to work. It's a good,
So on 146, which is a motion that you filed on March 17, it does not request sole custody. It basically leaves it at joint father making more money, not following the agreement. That was the issue as it relates to an enforcement around child support.
I did file another one. Like I said, I mean, I'd rather just resolve this than have to keep coming back again and again for nothing. If Matthew's willing to.
All right, so his motion on the request for sole custody is 142. So we will retain that motion to move forward. And what motions did I say went off so far? 137 and what?
It's 137 and 140.
Okay, so 142 to be heard. And where's this 146? And I don't see any. Remove father's visitation. So you asked for his visitation to be removed, but not the sole custody. So is that the motion you're seeking to follow through on?
Well, yeah, I mean, in the motion I had requested to remove it because he was refusing to give her back. He consistently keeps saying to you that I was refusing to pick up the child. I was actually begging, and I have emails of me every day. I have police reports to back this up as well, of me begging daily to get the child. He would say, the child's at my mother's house. He was lying about his address. I had a police go to the address. They confirmed that he hasn't lived there in months. He said that he stopped responding. So he was then telling me, if you want to get the child, you have to wait until Monday at 9 at the gas station, like the agreement says, even though I was asking Tuesday, Wednesday, every day.
But then you're saying, based on the agreement that you're seeking the court to adopt today, you guys have been able to come to a reset, correct?
We have, yes, and I feel that moving forward, this will be a good plan for us because it eliminates that loophole where before it.
Why don't you take the higher road, okay? Use this agreement as the way that you're going to proceed.
Right.
And then we will go from there. Okay, so I'm going to take 146 off, 146.10, because based on the agreement, we're indicating that addresses the issue. I'm going to reconfirm what you currently have as orders once I complete this agreement, okay?
Okay.
All right. So listen, both of you went to family today and you signed this agreement, correct?
Yes.
Sir?
Yes.
And you considered this agreement to be fair and equitable, sir?
Yes.
So the parties agreed to the following modification to their parenting plan. The mother shall drop off the child to the home of the paternal grandmother, as in his father, correct?
Paternal.
Grandmother, so his mother.
Correct, his
Every
mother.
Friday, any time from 8:30 a.m. commencing on April 15, 2022. Father shall drop the child off to the daycare each Monday by 9 a.m. with the exception of April 18, 2022 and April 25, 2022, or any other times that the daycare is not available. On those occasions, the father shall drop the child off to the home of the maternal grandmother any time after 8 a.m. So you guys understood those terms, correct?
Yes, sir.
On April 17, 2022, the father will drop the child off to St. Barbara Greek Orthodox Church in Orange, Connecticut by 10 a.m., and the mother will drop the child off to the home of the paternal grandmother by 2 p.m. on April 17th, correct?
Yes.
On April 24, 2022, the father will drop off the child to the mother's home by 10 a.m., and the child will stay with the mother. The parents agreed to celebrate the minor child's birthday with a joint birthday party to be held on May 21st, 2022. The parents further agreed to share any costs equally. the parents are requesting a hearing for the motion to transfer. Does that reflect your agreement?
Yes.
All right. So let me just confirm with you what else is here as an agreement. So that is a supplement to your initial agreement, which was dated 6/16 of 2021, that was adopted by Judge Murphy. Does that reflect your understanding?
Yes.
Yes.
And that's the one that allowed you guys, the good nights and all of that kind of scheduling activity. And that is dated 6/16/2021, and it's on pleading 128 in the event you guys have to, but you have the agreement, correct?
Yes,
Yes.
Your Honor.
Yes.
She keeps me blocked, so I can't call to talk to my daughter, and she never calls like the agreement says. That's one of the things that she doesn't follow. Is there a way that we can make sure that that's followed so I can talk to my daughter during the week when I'm not with her?
Your Honor, that was one of the things I was asking to modify because I have several recorded conversations of me trying to call either so he can talk to her or vice versa so I can talk to her. And in the background he's saying, "You're ugly, nobody loves you," calling me all these names, every name you could think of. And I have, every time that I've talked to him in any other way, he's very mean and says very mean things to me. And so I tried to even ask the police to tell him not to contact me unless it's via email only about the child. And so the FaceTime and the phone calls have been difficult because he uses harassing language towards me during those and uses it as an opportunity to insult me. And he has said these things in front of both of my children, and I've recorded many of these calls.
Can we hear these recordings, please?
I'm not doing a full-blown hearing today.
Oh, because that's not true. So
It
I'd
is
like to
true,
hear
and
the actual
my
recordings.
child,
She's totally making it up.
Yes.
Every aspect of this,
Most of it, yes.
most of it.
Yep.
So it's possible that some of this has occurred.
When we've been in conversations, when I was trying to talk to my daughter, she would jump into the conversation and be like, "Oh, well, you're too busy with your girlfriend," like little childish things like that.
You guys have got to grow up.
I agree.
I never once
Got
said
to
that.
grow up. You know what? You have a child now, and you need to just really grow up. Okay? So, listen, 2.5 is tough for phone calls, right?
No,
Because-
she's very smart.
Yeah, but nonetheless, it's a natural. Don't care how smart she is. Her attention span as it relates to a phone call, but you do have your right to your phone calls, and you basically, based on your agreement, indicated that you guys would agree to have those phone calls on a regular basis. Now, is it a FaceTime or is it a phone call?
I would prefer a FaceTime or a phone call. I mean, either one's fine. And I don't even need to talk to her. She can just give my daughter a phone because I have no need for conversation. And actually, another thing I'd like to request is when we do have to communicate, is there a way that we could set it up where it's a court-monitored app
Yes.
to
So there
defer
are two
from these
options. So I'm going to tell you what
discrepancies?
the options are, and I think you guys are right for this option.
Okay,
There's one called Our Family Wizard,
okay,
and that costs about $125 per year.
okay,
It is a more robust system that really, keeps track of a lot of details. The second option is something called App Close, which is free,
I'm sorry, what was it called?
APPCLOSE.
Okay,
And that's also quite usable as a means of communicating.
okay.
And so, what's your choice?
We can do the Our Family Wizard. I'd like something a little more comprehensive that will keep a better monitoring of what's really happening.
Your Honor, may I just mention that we previously tried using a parenting app called WeParent, and I actually had to delete it because he was sending me pornographic images of him with our previous babysitter that he was having an affair with. So he was using the app to not only harass me, say mean, hurtful things to me, but also sending inappropriate images.
You are young. You have a child together. You guys have got to stop this.
Is there any way we can order to be contact only about the child?
Well, that's what the apps are for.
Yeah.
So you wouldn't delete the app because it's important that you have that information as evidence in the event you need to provide it. Right?
Matthew offered to pay for the app. Can we order that he has to pay for it if we're going to be using that?
That's fine. I will be happy to pay for it.
Okay, so I'm going to put that in as the order. So you're going to use Our Family Wizard, correct?
Yes.
And both of you are going to download that. So today is the 12th, a Tuesday. Why don't we agree that you'll have that engaged and ready to go by the 15th?
Okay, and I can, yeah,
Okay.
that's fine.
So your daughter is going to be at some point very sensitive to what's going on with the Lord.
She is already.
And you guys are going to be teaching her some skills about her future engagement. And so somehow I hope you can get past this phase that you're in. If it's the angry phase, accelerate it so you can move on, okay? It's going to impact her. All right. So as a result of that, you are going to reach out to her when it's time for your did you set a time in the schedule of when you would have your phone contact?
No, we didn't set a time. The time.
Let's set a time now.
Okay.
Let's add a time to this new modified agreement. Each night with it to say good night. So what is normally a good night when she's heading to bed?
6:37, I would say.
I'd say like bedtime would probably be like, let's just say 7:30. 7:30 p.m.
Because she goes down around 8 o'clock.
Yeah.
Okay. So 7:30 is good?
Can we
7 o'clock is good.
do 7? 7 would be better.
Okay.
'Cause I usually have her in bed by 7:30.
At 7 o'clock.
Okay.
Okay. So 7 o'clock. You'll make your daughter available for a video call, and you in turn will do the same. All right, so the thing that you're modifying on here is father will drop child off at mother's house. You have modified it with your agreement at 10 a.m. Well, no, that was Mother's Day.
No, yeah, that was just that one day.
We modified number 12 on that agreement.
Number 12?
That was that, yeah.
Okay.
Yeah, it was the location was the biggest discrepancy.
So this new agreement modifies item number 12 on their agreement, which is dated 6/16 of 2021, on pleading 128. And everything else kind of remains the same, right?
Yes, and we put in some like clarifying details about for this year number 15 and number 16 and number 17, just because we just want to make sure we can have something that we can go with.
Right. Are those religious holidays?
Yes.
Yes.
Okay. All right. So let me just summarize. You guys have this agreement that you came to today that does some modification to your prior transition. So for the purposes of child support, I noticed that support enforcement is now involved, and so will there reductions from this paycheck? Has that been finalized?
He's self-employed, so he's responsible to pay himself. He has willingly not paid a single dollar. He said, I'm not paying anything unless the judge forces me to, which is why I was going to ask if maybe we could suspend his professional license because his home improvement contractor license, he just paid to renew it. Maybe we can suspend that until he makes a payment. Since
All right, so let's take it step by step.
Okay.
I'm going to reorder whatever delinquency. Do you have a figure on the delinquency?
I do. Child support is $3,314.47, and the child care is $1,640.53.
And what support is that? What did you use to come up with that figure?
That's from all the money that I've paid for child care to the babysitter since he stopped paying.
And then the child support, how did you come up with that figure?
I called Child Support Enforcement Services, and they gave me that number.
And when did you get that number?
That was on Friday, so it's probably the same.
All right. Are you disputing that figure?
Yeah, the babysitting, she was using a friend to babysit that she wasn't paying.
I never used a friend. I've had a babysitter. She even signed a W-9, and everything is legitimate. This isn't a hearing, is it? It isn't about money.
Yes, it is. She's addressing the money now.
Well, so, part of the issue is the fact that you guys are here, and I'm sensitive to the fact that you are indicating that you have not been getting child support, and there is a motion on here. I'm just allowing you guys some latitude because the court fortunately has a little bit of time to resolve some issues. So, given what she has said, we'll hold off on the daycare issue for a more full hearing. Child support has already been ordered, and there's no reason that you shouldn't be complying with that. So my question to you, does that $3,000 reflect your understanding of what you owe at this point?
Yes, as of our previous agreement, yes, it does reflect that. However, my circumstances of employment have changed drastically. I was making way more money when we agreed on that.
All right, so listen, as I told you, until there's a modification, that's what you're paying.
But I don't have it.
So,
How can I pay something I don't have?
okay, what was your weekly payment?
It's $120 a week.
Okay, and
I'm like scraping by right now. Like I could bring all my bank account statements and you'll look at them and be like,
do you
can't
understand
afford
that
it."
your daughter has to eat?
I do.
Okay, and she
But
has
she
to
only
eat
has-
7 days a week?
Yes.
Okay.
And I take her
And
3 of
that-
those 7 days.
What?
And I take her and feed her myself 3 of those 7 days. It's not like I'm not taking her. It's not like I'm one of those parents
So the other
that are
4 days she
non-existent.
shouldn't eat?
What?
The other 4 days she doesn't get to eat?
No, she does. But that's
But the
only
point
one more
is-
day.
Listen,
So does she pay for my 3 days?
Child support is child support.
I agree.
You're obligated to pay it.
Yes.
Okay, so what day of the week were you supposed to be paying this child support?
I don't think there's a specific day that we had. Did we have a day? I think we just did it at the end of the week, like
I
Sunday.
believe that it's Thursday on their end, but Your Honor, I just wanted to mention that Mr. Lodice is making significantly more money than he was when this order of $120 a week was placed in 2019.
Based off of what?
In
So
2019,
listen, sir, I'm going to reinforce that you have child support payments. They need to be paid every Friday by 6 p.m.
Okay.
And the child support payments based on the court order was $120?
$120 a week plus 50% of any unreimbursed child care and medical costs.
The unreimbursed child care, you're going to tack that on to the next hearing. So I'll add that to the next hearing because that requires, I think, the documentation and an argument about that issue.
Your Honor,
Yes.
As it relates to the child support, that was already established as part of your agreement, correct?
Your Honor, yes, that figure that we agreed on was a figure that we agreed on. That wasn't a court-ordered figure based off of my income. That was just something we agreed on at the time because I was making better money then.
Okay.
So it's not like that followed like my income and my finances and then we agreed. We just
So
agreed
there's
that.
been no motion for modification that
So-
has been granted. So that figure remains the same.
So I have to file a motion modification to change that?
And you have to prove basically that there is a need to modify it. In the meantime, your payments are $120 to be paid every Friday by 6 p.m. And what do you guys use, Zelle?
We were
So
doing a check, I think.
since
initially.
everything's under support enforcement services,
Oh yeah, we pay them.
isn't he supposed to pay them directly?
Supposed to pay them directly. And what have they done with this noncompliance?
So they filed a motion for contempt on him on his behalf, which was supposed to be on 3/9, but I was actually a little bit late to court that morning, and because they called us when I wasn't there, they gave us a continuance, which is for June 1st.
You were 2 hours late.
So I wasn't
Okay.
2 hours
I'm
late.
reinforcing the payment amount. Your hearing is June 1st with support enforcement for compliance. Okay?
And Your Honor, I'm just was asking again because, like I said, he started this business on April 16th, 2021. I also filed a motion for financial discovery because he has made substantial money in the stock market as well in the last 18 months, requesting to see the last 3 years of all of his financials because he has been significantly making more money. He stated to me on several occasions that he's making more money now than he ever has in his life now that he owns his own business.
Okay,
And
152 is your motion for discovery. So that will also be tacked on to the hearing.
on June 1st.
No, June 1st. So it looks like you guys have parallel actions, right? You have an action with support enforcement as it relates to the enforcement of child support. This court sets the child support amount. So the child support amount has already been set in this court at $120, and that's what should be paid. For the modification or the change of that amount, that happens in this court. Support enforcement just enforces what already exists. Understood?
So now if he doesn't pay the $120 by this Friday, do I have to file another motion for contempt?
I'm going to tack it on to these orders, and yes. And that would also be part of your next hearing.
And is it possible to suspend his HIC license until he pays?
No,
So that
we
means
need a
not
full
work?
hearing. We need a hearing on that. It is
Okay.
possible as a sanction, but not yet.
Okay.
So she wants to make me not work to pay her? That makes sense?
Well, you know,
afforded
the
a new
solution
apartment.
is to be able to pay her, and then I think we wouldn't be there, right?
I agree, and I want to pay her. It's not like I don't want to.
So she has a motion for discovery, which is pleading 152, will also be on, where she's asking for discovery on your financial information as a means of being able to establish exactly what your circumstances are. So you will need to look at that motion and be prepared for that too.
Okay.
And Your Honor,
So-
when will that be heard? When will that?
I'm going to have to ask case vote to schedule it. So given all that we've talked about here, I'm going to set you guys down for a 2-hour hearing at a later date on the outstanding motions that have been identified. So it includes your motion as it relates to the question of sole custody. It includes so his, I think, was 142. Hers is 146.10, and also motion 152. All right, so your agreement that you have reached otherwise for today's purposes, you consider it to be fair and equitable under circumstances and in the best interest of your minor child, correct?
Yes, Your Honor.
Yes.
And you're asking the court to adopt that agreement and enter it as an order today, correct?
Correct.
Yes.
Any questions?
Nope.
So you guys will get a date from Case Flow to schedule you for the hearing.
Okay, and all the current dates that we have coming up are still active? Because we have like, I think 3 or 4 more court dates already. Is there a way to
Here
like,
or in another court?
here? And one of them is even on a separate docket for some reason.
It's on the magistrate docket, the 6th one. That's about the contempt issue with the child.
What about the one on May 6th?
May 6th, I don't see you with a
That's
date.
a motion to transfer.
Okay.
Maybe they haven't calendared it yet, but it's not on the calendar yet.
It's weird because it's on a complete separate docket. So like when I go on the website, all the other ones are on this docket, and then that one for 5-6 for some reason is on like its own separate, like it's like a new case almost.
Okay,
Is what it looks
motion
like.
to it probably was assigned a new docket number.
Is there a way to do all this in like one hearing? Like all our cases? Could we just like pile it all in one and just go through it all line by line and just be done with it?
Your Honor, I'd rather not do that because each motion is separate.
So let me answer, right? Let the court answer. So the answer is that it's based on the court's availability as it relates to schedule. And
Because it's very hard for me to lose a day of work and come here. Like last time we were here Friday,
one thing I would suggest is probably rather than put this down for 2 hours, I'm going to put it down for a half a day. You guys need to have all your motions and your information ready in order to have the court proceed so that all the outstanding issues can be resolved. The financial issues as it relates to your payment is already in magistrate court. You need to have that date on 6/1/2022. The only other date I see is 6/14/2022. I'm going to mark that off because since you're seeking a hearing date on your outstanding motions, that was another resolution plan date. And if you are not going to use that, then we'll mark that off and have a half a day hearing.
I was told that the 6/14 date was for the motion to transfer on the family docket, and the 5/6 date was to motion to transfer on the magistrate docket. That's what the clerk's office told me.
You guys have the ability to see your docket?
Yes.
Okay. So I'm going to have, after this, the clerk's going to confirm the 5/6 day. I will add whatever my understanding is of that to the order so that you guys can see it, what the 5/6 days. You already know what it is?
Yes,
Okay.
they do have a hearing on the 6th of May, and that is through magistrate. It is the motion to transfer.
But 6/14.
Magistrate?
so confused.
Okay.
Yes, it is.
All right, we'll look at that 5/6 day. All right, we're good?
Well, I just wanted
I
to
don't know.
confirm about 6/14.
I'm very
That's
confused.
still on as the motion to transfer to the family docket because that's what that was for. 6/14.
What is? I don't know what that means.
It's right
A
here.
resolution plan date is not going to take up the issue of a transfer.
So what was that resolution plan date?
What they do is they give you 2 bites of the apple with a resolution plan date. In the event, you can use that second date to come to a global resolution. What I'm hearing based on your continued dispute is that you need hearing time.
Yes.
Those resolution plan dates are like this. You don't even get as long as you've been sitting here today. And the only reason you're sitting here today for this length of time, because this was scheduled for a case date, and I had the ability to listen to you for a little bit because I didn't have anything lined up after you.
Thank you.
I'm going to put that date as off and also put the motion for transfer on the date that they're going to schedule for the half a day.
Okay, which hasn't been scheduled yet.
Has not been scheduled yet.
So we'll do the motion to transfer as well as all the other issues on that day.
Yes.
Okay.
And I'm setting it up for a half a day. So you guys are going to remain self-represented, correct?
Yes.
Well, I may
afford a
retain
lawyer.
an attorney.
All right. If you decide to retain an attorney, then you'll need to have the attorney know the date.
Okay.
If you're not retaining an attorney, you need to come prepared with all your proof that you're trying to submit to the court through evidence of what you are arguing.
Okay.
Okay? All right. We're good?
Yes.
Yes. So just one more thing. Just so we have 6/1, and that's the big court date for everything. That's the half day.
Magistrate court.
But we also have the 5/6 is still on also. And those are the only 2 left. Correct?
I'm going to put in my orders after today. So look at my orders after today. I'm
Okay.
going to double check your 5/6 day.
Okay.
I think it's unusual that your transfer, which is what I think she's indicating, would be at magistrate court. Magistrate court doesn't normally take motions on transfer.
Okay.
That's here. If that's the case and the 5/6 day is off, I will indicate that in my order, or I will tell you what the 5/6 day is for. So review my orders by the end of the week, which is usually when it gets posted, and that will tell you about 5/6.
Okay. Thank you, Your
In the
Honor.
meantime, we are going to schedule a half a day for the other motions that we have identified.
Okay.
Okay?
Thank you, Your Honor.
All right. 6/1, however, stays on because that's about the enforcement of child support.
And once he does make a payment again, just file another contempt myself through family court. Since you ordered today, he has to start paying on Friday.
Yeah, and it's kind of doubling up because the order exists, it exists, okay? I'm
Okay.
reinforcing the order.
Thank you.
Okay. All right.
Oh,
So
you
we
need to
will
place on
adjourn
that?
for
Okay.
the lunch break or take a recess. And then we have results this afternoon? Okay, we're not in live court. Okay. So I think we're adjourned for live court.
Yes, Your Honor. All rise. Court is now adjourned.